This case, which is often taught alongside Gibson and the Manchester City Council, arose from a council program in the early 1970s, where the Conservative-dominated council decided to reduce its stock of council housing by allowing long-term tenants to purchase their houses. Storer, like Gibson, was a tenant who wished to buy his home. The council's intention was to undertake the whole transaction in as informal a way as possible, and so a very basic sale form had been generated and was sent to Storer, who had expressed an interest in purchasing the home. The council sent the draft agreement along with a letter which said, "I enclose the agreement for sale. If you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the council in exchange." Storer did just that. The form, however, was missing one element: the date upon which the contract was to settle. The council staff were then overwhelmed with work, and the contract was never returned to him. About this time there was a council election, and the Conservative council was replaced by a Labor council who didn't want to sell the homes. The Labor council decided to put a stop to any sales where there was no formal contract, and so they wrote to Storer to tell him the sale would not go ahead. Storer sued, seeking specific performance of the sale. The question then was whether the council's letter was an offer which was capable of acceptance by Storer. The court said yes. Lord Denning said the acceptance was made when Mr. Storer did sign it as he did and return it as he did. It was then that a contract was concluded. The town clerk was then bound to send back the agreement signed on behalf of the corporation. The agreement was concluded on Mr. Storer's acceptance. It was not dependent on the subsequent exchange. This case emphasised the rule that as soon as one party communicates to the other, indicating that they are prepared to be bound immediately by a certain obligation, they have made an offer. If the offer is accepted, then there is a contract on foot, even if there are still some other administrative details, such as, in this case, the date of settlement, to work out.